Welcome back to the RGE Limited Boardroom. Adjust your lighting and pour yourself a glass of something that appreciates in value while you sleep, because today we're discussing the ultimate modern asset, the invisible empire of intellectual property. If you think your wealth is safe just because your factories have tall fences, you are living in the past century. Today, the real war is fought over ideas, brands, and algorithms. And as we see from the recent high level summits in Geneva and Tanzania, if your legal team isn't ready for the digital age, your assets are already bleeding. Here is your high society briefing on the AI collision and the damages trap, served with the signature Oksana Rabbit's edge. The scene: the collision of AI and tradition. In April 2025, Chief Justice Professor Ibrahim Hamis Juma delivered a wake up call to the justices of appeal. He warned that the unprecedented rise of artificial intelligence is reshaping industries and putting massive pressure on traditional legal doctrines. In this boardroom, we know that technology moves faster than the law. The Chief Justice urged the courts to modernize their interpretative approaches. If your legal team is using 1990s tactics to protect your 2025 AI generated assets, you aren't an innovator, darling. You are a victim waiting to happen. The scandal. The phantom profits. Let's talk about what happens when someone steals your intellectual property. At the 2025 WIPO Intellectual Property Judges Forum in Geneva, Tanzania's principal judge, Honorable Dr. Mustafa Siani, delivered a masterclass on the exact math of IP litigation. He brought up the chilling case of Tanzania China Friendship Textile Company Limited and Nida Textile Mills. The plaintiff proved copyright infringement and won, quote, general damages. But when they asked for specific damages and the infringer's profits, the court said no. Why? Because the plaintiff's lawyers failed to provide evidence directly linking the specific damages to the infringement, and they didn't properly plead the claim for the infringer's profits. The boardroom verdict. If you catch a thief, you don't just ask for an apology, you demand their bank account. But in our world, if you are strictly bound by your pleadings, you have to explicitly pray for the infringer's profits in your paperwork. And if you don't, the judge cannot hand them to you. The trap, the discretion lottery. Dr. Siani pointed out a glaring vulnerability in the Tanzanian IP system. There is no codified formula for calculating damages. We don't have, quote, statutory damages, defined ranges for awards, like they do in Singapore or Canada. Instead, general damages are awarded entirely at the court's discretion. In the RGE Limited Boardroom, we despise the word, quote, discretion. Discretion means unpredictability. It means two different judges could look at the exact same theft and give you wildly different payouts. Dr. Siani himself admitted that statutory damages would be an effective cure for this inconsistency. But until the law changes, your lawyer's persuasive abilities are the only thing standing between you and a hollow victory. My final takeaways. Darlings, Tanzania is no longer playing in the minor leagues. Dr. Siani has just been appointed to the prestigious WIPO Advisory Board of Judges. And Tanzanian IP decisions are now being globally broadcast on the WIPO Lex database. The world is watching how we handle corporate warfare. Here are your boardroom lessons for protecting the invisible empire. Plead everything, prove everything. Specific damages in an IP dispute must be specifically pleaded and strictly proven. Do not walk into court with a quote rough estimate of what the infringer stole from you. Bring the forensic accounts. Claim the enemy's spoils. If someone violates your copyright or trademark, ensure your pleadings explicitly demand the infringer's profits. Don't leave their ill-gotten gains on the table. Prepare for the AI shift. The highest courts are already re-evaluating their doctrines to handle digital transformation. Ensure your IP portfolios are audited for AI vulnerabilities before your competitors use the loophole to drain your market share. Now, if you'll excuse me, I need to go audit our trademark registrations. I have no interest in relying on a judge's discretion when it comes to the value of my brand.